All right, well, welcome back, everybody, to the second panel to discuss Jeff King's paper, A Democratic Case for a Written Constitution in the UK. And we're really delighted to be joined by another array of really expert panelists. So I'm going to, again, introduce them in the order in which they're going to speak. So firstly, we're going to have Joanna Cherry, QC MP, who has been a Member of Parliament for the Scottish National Party for Edinburgh South West since 2015. She's been the SNP spokesperson on Justice and Home Affairs and is currently the Deputy Chair of the Joint Committee on Human Rights. Prior to her role in Parliament, she served as a barrister and took silk in 2009. So great, warm welcome back, Joanna. Nice to see you again. And then we've got, the next speaker will be Carwyn Jones, currently a professor at Aberystwyth, but in a former life he was First Minister of Wales from 2009 to 2018. He represented Bridgend in the Welsh Parliament for 22 years, till 2021, and he too, in a former life, was a barrister. And welcome, Carwyn. And finally, we've got Hannah White, who's the Deputy Director of the Institute of Government. She has strategic oversight of the work that the Institute does on government, parliament, and the civil service. And she, in a previous life, ran the Committee on Standards in Public Life in the Cabinet Office. So we've got three very experienced members of government from the different constituent parts of the UK to talk to us in this second session. And as we did before, we'll start off with each of them speaking for 10 to 15 minutes, followed by a response by Jeff, followed by opening to Q&A. Joanna.
Well, thank you very much indeed, and I just apologise in advance that I'm a bit croaky, but I've had a PCR test and it's not COVID, so you're all right. I'm really delighted to be back here. I was here a couple of years ago in February 2019 at a really excellent conference on remaking the British Constitution, when I think it was fair to say that there was great interest in what's happening in Scotland. I've not moved forward quite as much as some of us would have hoped since then, I think partly because of the COVID crisis. I'm also really grateful to Professor King for stimulating this debate with his paper. I really enjoyed reading it and I've found the contributions we've had so far today really interesting. I'm going to deliver my reflections on Jeff's paper very much from my perspective as a nationalist politician whose main aim in politics is to see an independent Scotland, but also as a lawyer who sees the framing of a written constitution for an independent Scotland with appropriate checks and balances as very much central to the project. And frankly, I think a written constitution for an independent Scotland is much more likely to come about than a UK written constitution for reasons outlined by at least one of the previous speakers. I think Nick said, I don't think either main party is terribly interested. And my impression is that there's not really an appetite, there's no great driver. Even the Lib Dems you would expect to be noisy about this issue are rather quiet about it at the moment. But if there were to be a UK written constitution, I'm afraid to say I agree with many of the reservations expressed by Chris and Nick in the earlier session about Jeff's process, because from a Scottish perspective, I would see Scotland as very much being in a very small minority in any constituent assembly to draw up a constitution for the UK. And I think not only would be outnumbered significantly by virtue of population size, but also our politics in Scotland are very different. You know, for better or for worse, the Scottish National Party, my party, is utterly dominant in Scottish politics just now. I personally prefer I would prefer to see a better opposition in Scotland. I think it'd be healthier for Scottish democracy. But we are where we are. So we've got one very dominant party in Scotland and then two parties in England. And I'm not sure that Jeff's plans could really take that on board. And of course, I would also very much share the reservations for Northern Ireland and indeed for Wales. But many of the issues regarding the process of developing and adopting a codified institution for an independent Scotland are similar to those in the debate about the UK. So I hope my remarks will be of wider interest. Others, of course, are very different. If Scotland were to adopt an independent written constitution, we'd be doing so in the context of of not setting up a new state, because it's important to remember that Scotland was a state from 1320 to 1707, but re-establishing a modern state. And I think, you know, that's very different from trying to reset the unwritten British Constitution. We'd be embarking on a new project, which in a sense makes it easier to have a written constitution. I take it as a given, therefore, that an independent Scotland should have a written constitution. And my remarks today are going to be more focused on the aspects of Jeff's paper about how you draw up a constitution, who draws it up, and how do they do that. And I'm really very attracted by Jeff's proposal of a constituent assembly consisting of representation from the political parties as well as direct citizen participation. Now, I would say that, wouldn't I? Because I'm currently an elected politician, but I think there's very strong force in the argument that having political buy-in and political expertise is important as long as it doesn't outweigh the citizen representation aspect. And it's interesting to look back to the summer of 2014, which was prior to the independence referendum in Scotland, when my colleagues in the Scottish Government held a consultation on what Scotland's written constitution should look like. And now Professor Alan Rennick, one of Jeff's colleagues at UCL, reached the same conclusion as Jeff has reached in advising the Scottish Government in his response to their consultation, that what we needed to do was to have a constituent assembly draw up our independent nation's constitution, consisting of a similar proportion, 2/3 citizens, 1/3 professional politicians. And this is kind of a live issue in Scotland at the moment, because as you may know, the First Minister of Scotland has said that there will be another independence referendum in 2023, COVID permitting, and she's put the current president of the party and former Constitution Secretary in Scotland, my friend Mike Russell, in charge of preparations for a second independence referendum. And the SNP had an online conference back in September when Mike told us that he's working on putting a transitional constitution in place by next year, 2022. Now, this, of course, prompted a degree of controversy within the Yes movement, because people said, well, who's going to draw up this constitution and how are they going to do it? And the respected nationalist commentator, Leslie Riddick, who was here at the conference in February 2019, she's a pro-independence, but not a member of my party, and a friendly, helpful, but also very challenging critic, which is a good thing in my view. She expressed concern about a transitional constitution. She said the job's far too big for one party or one side of the constitutional debate, and the task of framing a constitution for an independent Scotland must be handed over to the people, although query, of course, as we heard in the previous session, who the people actually are. Other commentators, like Dr. Elliot Bulmer, who's written a lot about Scotland's constitution, they say, well, let the experts devise the transitional constitution, and then you have that in place. If there's an independence vote, you've got your transitional constitution, and then later on you have a democratic, participatory, inclusive process. And, you know, the Scottish National Party have been working on a written constitution for Scotland for many, many years. My late friend, Professor Sir Neil McCormick, who many of you may know more as a jurisprudence and a politician, but he was, of course, a member of the European Parliament and for many years Vice President of the Scottish National Party. He did a huge amount of work between the mid-70s and 2002 in drafting what was called in 2002 a Constitution for a Free Scotland, and you can actually get the text of it on Wikipedia. Not normally one for recommending Wikipedia, because if you read my Wikipedia entry, it would make your hair stand on end, and I don't necessarily think it identifies me correctly, but I think this entry in Wikipedia is probably pretty accurate. But as Elliot Bulmer's identified, that since the SNP actually came into government in 2007, our focus has changed from pre-independence constitution making to post-independence constitution making. And it was in that context that this consultation took place in the summer of 2014, prior to the first independence referendum. The Scottish Government wanted to know what people thought about how we should go about drawing up our written constitution for an independent Scotland. There was no question that there should be a written constitution, and the government were very clear that they felt that the process of drafting that constitution had to be a process of defining what sort of Scotland we wanted to have. So the part of Jeff's paper that interests me the most is this idea of the constituent assembly of politicians and citizens. Citizens' assemblies are very in vogue in Scotland at the moment. We've had a couple that perhaps not being as impactful as the citizens' assemblies in the Republic of Ireland, but people are quite interested in the idea. But again, I really like the idea that when you're drawing up a constitution, it would be a good idea to have political input. And I think the experience of Iceland shows that if you don't have political input, you might come up with quite a good project, but then the politicians aren't too keen on implementing it. I think it's so important that that constituent assembly should be properly informed. But I think we very much talked the last time I was here in February 2019, when we were talking about citizens' assemblies, the importance of having experts on tap rather than on top. And I think there's great concern in the wider independence movement in Scotland that my party might just impose a constitution written by a few self-selected experts. But in fairness, I don't think that's what my colleague Mike Russell is at all suggesting. I think he's suggesting that as a transitional constitution and then moving on to some sort of citizen-based process in the long run. And I think he would do very well to look at Jeff's proposals, and indeed Professor Alan Rennick, as he now is, and congratulations to him. His proposals he made back in 2014 when he suggested to my colleagues in the Scottish Government that they should look at the precedent set by Ireland's Constitutional Convention in 2012-2014. And we should have something based on the majority of the members coming at random from the electoral register through a process of sortition, and then a minority of politicians chosen by their own parties. And I think Alan was very keen to say you really need the time. This body must be given the time and the resources for extended learning, deliberation, decision phases, backed up by consultation with experts, activists, and ordinary citizens. And then he said finally that the convention's recommendations should be put to the people in a referendum, which made me feel, oh gosh, not another referendum. But I was just being reminded at the tea break that some of the research that Alan Rennick's current project is carrying out shows that people aren't as antipathetic to referendums as we are led to believe, although I think I'm getting a bit antipathetic to them myself. And I think it's unfortunate, as an aside, that the debate about whether or not Scotland should become an independent nation has become very focused on whether or not Scotland can hold a referendum under the terms of the 1998 Scotland Act, because of course that's only an act that governs devolution, a creature that's barely 20 years old. The Act of Union is more than 300 years old, and I think we need to look at the process by which Scotland becomes independent through a wider prism than just the prism of devolution. But that's just my little one of my hobby horses. Alan Rennick said in his response to the Scottish Government's consultation in 2014 that in the Irish model, concerns were initially raised that the politicians would dominate and the ordinary citizens' voices would not be heard. But happily, the experience didn't bear that out, and the research and the evaluation carried out shows that that didn't happen. And I think if the Constituent Assembly is properly moderated and facilitated, it shouldn't happen. So I think this is a good idea for Scotland, but not for the United Kingdom. I think it's a pity in Scotland that we've not done more work on realising what Alan Rennick suggested back in 2014. And I really hope that Jeff's paper, which I'm going to be writing about and talking about a lot in Scotland, will re-stimulate the debate in Scotland about the best way to go about drawing up a written constitution. So I'm really grateful for the opportunity to take part today, and I found the contributions in the first part fascinating, and I'm really looking forward to what my colleagues will say this afternoon. Thank you again for the invitation. It's a real strong pleasure to be back at the Bon Iver Institute again and back in Oxford, so thank you.
Thank you very much, Joanna. So, and now we're going to hand over to Carwyn Jones. Carwyn.
Thanks very much indeed. First of all, my thanks to the Bonavero Institute for organising today, and to Jeff, of course, for leading what was a fascinating debate, I thought, earlier on. Anthony and Chris will be unaware of the fact that they are towering above us on a screen like Olympian gods. I hope that they're less harsh in their judgments when we finished our section this afternoon. The very first two lines in Jeff's article say that written constitutions have often been viewed as a bridle for unchecked political majoritarianism. We don't even have that in the UK. Governments are usually elected by a minority of the voters. And having been elected by a minority of the voters, they can then do, or parliaments can then do whatever they want for 5 years. That is not democracy. If you're saying the minority decides what a parliament should look like, and then there are no rules at all that govern what that parliament can do, it's a stretch to describe it as a working democracy. Now, I agree in principle with the idea of a written constitution. It's by far the easiest way of defining who does what within the UK, but it is the hardest to deliver. Nick is right. There's very little interest outside a small number of us, formerly politicians, now on the way to being academics, in the idea of a written constitution. But it is nevertheless something that is very much to the fore in terms of the way the UK is operating now. The article didn't mention Wales at all. I'm going to mention Wales. I was tempted to deliver this entire address in Welsh just to make the point, but I'll spare you that. And the reason why it's important to mention Wales, and indeed Scotland, is because Wales and Scotland have been driving the case for constitutional change. It hasn't come from England, it hasn't come from Westminster, it's come from Scotland, from the SNP, whose idea of constitutional change, of course, is independence, we know that, and within Wales from Welsh Labour, an autonomist party, a home rule party that doesn't go as far as wanting to set up a separate Welsh state. And that's where most of the drive has come from. It hasn't come from Westminster. And certainly, I mentioned the idea of a constitutional convention in 2013. I was described as an anorak by David Cameron for saying that, but nevertheless, I did say it. And I think now the time has come. The situation is so acute that we need to have a way of reforming the constitution if the UK is going to survive. The UK is 100 years old this year under its current borders. It will not be here in 100 years if things continue as they are. And these are not obscure arguments. From my perspective, as a leader of a government in Wales for 9 years, we had a constant low-level battle against the hurdles put in front of us by the devolution settlement. Because arguably, in Wales and Scotland, we have written constitutions. They're based on the various pieces of legislation. First of all, in Wales, the Government of Wales Act 1998, and the other three that came afterwards to try and rectify some of the faults in that act. And they govern the way in which Wales and Scotland operate, in the way we have a written constitution. But they also make it clear that the UK Parliament, not the UK government, there's no hierarchy of governments, the UK Parliament can still do whatever it wants. So the UK Parliament could abolish the Welsh Parliament without reference to the people of Wales. That's wrong, both morally and in terms of democracy. We have the Sewell Convention. Many of you will be aware what the Sewell Convention is. The UK Parliament is not meant to legislate in areas that are devolved without the consent of the devolved legislatures. They're ignoring it. The EU Withdrawal Act was the first example of that. We were told at the time it's a unique situation. Then they did it again for the Internal Market Act. They will do it again for the Subsidy Control Bill, which is so insidious that it gives the ability to UK ministers to fix the subsidy control regime in England's favour and use it against everybody else. That's how insidious it is. This is how acute the situation is from a Welsh perspective. It's not an obscure argument that exists outside of reality. This is what we face on a daily, well, it's what I used to face in my old job, as a daily, on a daily basis. So what we cannot do is treat the UK as if it were an indivisible whole. The UK is made up of four, I'm going to call them units. Wales is a nation, I'm going to call them units, but four distinct units. Within Welsh Government, we didn't see Manchester as our equivalent. We didn't see London as our equivalent. We saw England as our equivalent. Despite the difference in size, we were one of the four constituent nations as we saw it, of the UK. There's a debate about Northern Ireland, I know, and I'll come on to that for Chris. So Chris hears what I say about that in a little while. And the pressure is largely coming because there are significant numbers of people now in Scotland, Wales and Northern Ireland who don't wish to be part of the UK. About half the people of Scotland, give or take one way or the other, would vote for independence. Over 40% of the people of Northern Ireland would vote to join the Republic. A third of the people of Wales would vote for independence. Not a majority, but that's 3 times bigger than it was, believe me, about 5 or 6 years ago. So there are pressures within Scotland, Wales and Northern Ireland that make it imperative that we look now at how the UK can change and how we get constitutional change to ensure a greater sense of partnership amongst the 4 nations of the UK. This means ending parliamentary sovereignty, this great fetish, the view of one man in the 19th century, an Oxford professor I know, adopted by the UK Parliament. And why wouldn't they adopt it? It said, you can do whatever you want. No laws bind you. Of course you can adopt it. There's even a question as to whether it applies in Scotland. McCormick, a Lord Advocate, of course. Parliamentary sovereignty is not fit for a devolved world. It cannot be right where one parliament says, we have the power to overturn everything you do over there in Cardiff, and we can abolish you as well while we're at it. Now, a written constitution would make it clear what the powers of the UK Parliament were. There are other ways of doing it. You could introduce, for example, constitutional arrangements that are protected, certain things the UK Parliament couldn't do, such as abolish the devolved parliaments without their consent. But that would mean inevitably limiting and ending parliamentary sovereignty in any event. It's either unlimited or it's not. What is the UK's purpose? A written constitution could define that. What is the makeup of the UK? You might say, for example, there are 4 parliaments. England, Scotland, Wales and Northern Ireland. They all have equivalent symmetrical powers. And then there is a UK Parliament whose powers are defined. It doesn't need to be a supreme parliament. As long as you know who does what, the UK Parliament could deal with, for example, borders, immigration, the fiscal and monetary union. All this could be laid down in a written constitution. But what cannot happen is a settlement where the UK Parliament is at different times the UK Parliament, the GB Parliament, the Parliament of England and Wales, or the Parliament of England. That doesn't work in the long term. How might this come about? Well, as somebody who's advocated a constitutional convention, I'm going to advocate it again. But I don't underestimate the real obstacles that it would face. Who would choose the convention? Now, I certainly would be uncomfortable with a convention that was elected across the UK. Now, from my perspective, I want Wales to be an equal partner within any convention. Otherwise, it doesn't have any credibility for those of us outside England. Who approves whatever that convention actually produces? It would have to be through referendum. Jeff has said that. But it could only have credibility if it was ratified separately in each of the 4 parts of the UK. Then it has that level of credibility. It couldn't just be ratified across the whole of the UK with Scotland, Wales and Northern Ireland opposed to it. That puts us back into exactly the same situation as we face now. What then should the vision be? We develop a constitution, and in time a written constitution, that recognises that the UK is made up of 4 territories that have their own sovereignty but choose to share that sovereignty where it makes sense to do so. And that means, say, having a parliament in each of those 4 countries. It also goes some way, I hope, to answering the question that Chris rightly put, and that is, what do you do with Northern Ireland? And my wife is from Northern Ireland. She grew up in Belfast in the 70s and the 80s. She identifies as Irish. She has an Irish passport, as do my son and daughter, and I don't. It's a sore point. I'm not going to go further than that. But I know what Northern Ireland is like, and I know the precarious constitutional situation that can exist there. That kind of model, where Northern Ireland opts in to being part of a UK of 4 distinct units, at least solves the issue of the future of Northern Ireland being outside of the control of the people of Northern Ireland, which I entirely accept in terms of what Chris has said there. I've lost track of time, so I'm going to draw to a close now by simply saying this. We don't need a cataclysm or a revolution or war to have a written constitution. That's when things become too acute. But we do need a written constitution when pressures start to be put on the Union that make it likely that in the future that it might break up. And that's why a written constitution is something to consider. It can't just be the be-all and end-all. There are other things we can look at as well, but time has come to an end. But certainly, a written constitution, if the time to start considering it has not yet come, then when will that time be? Thank you.
I think Chris has left. He could only stay. Oh, I see. Okay. Okay. Great. Well, thanks very much indeed, Carwyn. That was really engaging. And now we're going to turn to Hannah. I'm not sure. I think Chris did say to me he probably would only be able to stay until 4:30. So I think he's gone. Right, Hannah.
Balance my computer here and hope it doesn't fall on the floor. I'm really delighted to have been invited here today. Thank you so much to the Bonavera Institute and to Jeff, and to have the opportunity to offer some reflections on Jeff's fascinating article. In my view, one of the strongest aspects of Jeff's case is that he takes care not just to make a principled case for a written constitution, but also to think about the practicalities of how that could be implemented. And in this spirit...
Does anybody sing or have any funny stories to tell or anything like that?
It's quite random.
No.
Is it something I'm doing with the computer?
Yeah, it might be. Let's have a quick look. Oh, Chris is on the phone, on the call. Okay, hang on a sec.
Oh, hang on, participants.
It might be worth saying that the chairman had some difficulty
isn't on
with
here.
accessing the board meeting which we have just held. So maybe Stephen or you can contact the chairman independently by phone.
No.
Once again in my life, thank heavens for Gayatri. Right.
Okay, let me try and continue. So as I say, in the same spirit, I'm going to skip lightly over some of the questions of principle that have been raised already and engage with some of the practicalities of how we would actually implement the idea of a written constitution in a hypothetical situation where that argument had been won. Mine is very much a Westminster parliamentary and government perspective based on my experience working in the House of Commons and in Whitehall. And I feel that as the sixth of six speakers, I have a responsibility to be brief. So I shall confine my remarks to 5 questions. And these are going to be about the design and the process of writing the Constitution and how to disentangle that from the interest of elites, the difficulty in interesting the UK public in the idea of authorship, the consequent difficulty of securing a constituent assembly as a mechanism for drafting the Constitution, the role that political parties should play in such an assembly if it were to happen, and the process of interim review. So firstly, and perhaps most fundamentally, it seems to me there's a question about how to disentangle the public argument for and design of the process from the interests of elites such as ourselves. This links to the question that Stefan Thiel raised in the last session about a meta-constitution sitting behind the written constitution. The incrementalist reformers are right to say that there's no clamour from the public for wholesale reform of the constitution. The case, as Jeff makes it, is a rationalist one for the benefits of the end state and not for the details of what that written constitution would look like. But in a thought experiment where that case were accepted, experts would then have to be involved to plan and facilitate the processes of deliberation and drafting needed to produce something as complex and extensive as a written constitution. I find it hard to imagine, although this may be a failure of my imagination, how that design could be done in a way which did not significantly shape the outcome of the process. If the process were to start from a blank sheet of paper, we could be looking at a completely new kind of constitution. In principle, according to Jeff's argument, that would be completely fine, but what account should be taken in the process of the status quo, of its benefits and its drawbacks, as discussed amply by previous speakers? Such decisions would doubtless influence the outcome in terms of the nature of the constitution drafted, and it would influence the eventual likelihood of it being adopted in a ratificatory referendum. Conversely, if the process were designed to work back from the status quo to test and examine key aspects of the existing constitution, the eventual outcome could be quite different. So the design of the process will be key to the outcome. In an ideal world, I think you'd start with a wide-ranging and well-informed public debate to set the basic parameters before the Constituent Assembly began its work. But we all know that we're not living in an ideal world. Perhaps the role of experts in designing the process is simply a constraint we need to accept, but I wonder how we could prevent it undermining the validity of the public authorship to which Jeff aspires. To move on to the question of that authorship, another concern I have is about how difficult it may be to interest the people of the UK in the idea. As a trustee of Involve, the charity which advocates for participatory and deliberative democracy, and having seen the citizens' assemblies which they run, I do not doubt that it will be more than possible to recruit a descriptively representative group of people, via sortition as Jeff recommends, who will be more than happy to give up their day jobs for a period of years in order to participate. But amongst those not directly involved, I think interest in the writing of the Constitution will be low. This is purely anecdotal, but the Guardian columnist, Raphael Baer, has told me that every time he chooses a constitutional theme for his column, the number, rather than a sort of current issue of politics or policy, the numbers of readers for his column drop off dramatically. So the Guardian doesn't let him do it very often. So even when, for those of us in this room, the issue might seem pressing and vital, the public simply aren't interested. It might not matter if the vast majority of the public didn't engage with the project of constitution writing, but it might be problematic if it undermined the legitimacy of the means of drafting it or of the provisions that the Assembly ultimately produced. During the process of Brexit, and since the UK left the EU, I would say that we've seen a really remarkable lack of interest from large sections of the public in the question of how the departure has been achieved, as opposed to the outcome. Even something as significant, and as already discussed today, as the Northern Ireland Protocol, a provision which some argue has the potential to damage the Belfast Agreement, remains mostly confined to occasional stories on the business pages of broadsheets, in England at least. So I think there is a question about whether and how sufficient enthusiasm could be galvanised amongst the public to support a constituent assembly to take on, as Jeff puts it, the acts of writing, deciding and legislating that will provide the opportunity to confront big constitutional questions and decide. Instead, I think, there will be more powerful and organised voices arguing for alternative sources of authorship. And here I want to come on to the difficulty in securing a constituent assembly as a mechanism for producing a written constitution. I would expect that many individual MPs, rather than the parties or the government, will want parliamentarians to be the constitution writers. I completely agree with Jeff that Parliament is not equipped to take on this role. Not only is it dominated by party politics, it does not have the time to devote to such an important task. But MPs will not necessarily agree, and nor may their constituents. One select committee chair told me that he had received letters asking why, for Climate Assembly UK, the big citizens' assembly which was held quite recently, why MPs had delegated their role to 100 members of the public. Feelings are likely to run higher about MPs outsourcing a project to set the constitutional rules for the country, and presumably also about the costs entailed. The government will not want Parliament bogged down with constitution writing, but I suspect that the idea of a conventional commission will seem attractive to the executive, given the influence over the setup and final parliamentary lock that it would necessarily entail, which, as we all know, is effectively an executive lock. Commissions have been a tried and tested means for the executive to influence the outcome of constitutional deliberations on a much smaller scale, and I think the route would commend itself to any government. They would be willing to trade off the risk that a commission would appear to be an elite project against the benefit of a veto over the outcome. I can just about imagine circumstances in which a political party might advocate for a written constitution for the UK, although I think the evidence is that aside from Brexit, major constitutional change is not a vote winner. But I think it a real stretch to believe that a party might advocate specifically for a constituent assembly as the means to achieve it. In fact, it's those with the fewest vested interests in the current system, the public, who would have the most to gain from the idea of a constituent assembly, in terms of a non-partisan but representative mechanism for drawing up rules on their behalf. But the public is also the least likely to advocate for its adoption. Although a constitution authored by Parliament or a commission would be suboptimal in Jeff's terms, I wonder whether he just thinks it's less likely to be successful, or whether at some point the risks of political tribalism or distance from the people would make it so seriously illegitimate that it would not be preferable to the status quo. To pick up on that risk of tribalism, my next question is about whether it would be appropriate to give political parties the prominent role which Jeff suggests in the process. I agree that political buy-in to the outcome of the assembly would be crucial, and that party politicians are among those individuals with the most sophisticated understanding of what it takes to make a constitution work. But throughout my career, I have been repeatedly stunned by the lack of understanding of the constitution exhibited by what Jeff calls the grizzled party hacks, apart from the very specific aspects which affect their daily existence. I think practical experience of operating the constitution will be important, but I also think that the Assembly would not be able to rely on political parties to bring the requisite knowledge of the whole constitution. And if political parties were overrepresented in the process, there would be a real risk that recent tribal concerns might inappropriately shape it. As well as questioning whether political parties really have the privileged understanding of the system which Jeff claims, I also wonder whether they still convey the legitimacy which they once did, given low levels of political party membership in the UK. According to the latest figures from the House of Commons Library, only 1.7% of the electorate were members of the Conservative, Labour and Liberal Democrat parties in 2019, and just 3% of Scots were members of the SNP. I accept that parties will dominate the referendum campaign, and hence the likelihood of any written constitution being accepted, but I'd argue for a smaller proportion of party politicians joining the Assembly, perhaps only half or even just a third being elected, as Jeff recommends and as Joanna and Alan Rennick have advocated. I have, being a former parliamentary clerk, other questions and observations about the process, which I don't have time to go into. These are practical questions driven by no doubt too lengthy experience of working with parliamentarians and on the legislative process. They include what the process of consulting Parliament would look like, given that for these purposes and many others, Parliament has no single authoritative individual or group that can speak on its behalf. Would, when the Assembly wanted to consult Parliament, would that mean either consulting all MPs as individuals and peers potentially, or would it risk giving the political parties a further bite of the influencing cherry? I also wonder how the idea of original legislative authority would work in the absence of an executive-like power to direct initial drafting ahead of detailed engagement by the Assembly. My own experience of drafting by committee does not fill me with optimism. Finally, I wonder how you would avoid a referendum question being simplified and hijacked in such a way as to undermine whatever careful democratic process had been constructed to produce the written constitution in the first place. Finally, to step away from the concerns of a former parliamentary clerk, one of the proposals I particularly like in Jeff's case is that the constitution, once drafted, would automatically be reviewed every 20 or so years. One of my long-standing aspects of discomfort with the concept of a written constitution is the idea that it would fix rules determined at a particular point in time in a specific socio-political context for all time. This is precisely the issue which Jeff seeks to address with the idea of a once-in-a-generation review. The idea of an assembly partially appointed by sortition would be particularly attractive in this context, helping to ensure a descriptively representative group of members on each occasion that the constitution was reviewed, reflecting changes in the demography of the UK over time. However, I do have some concern about the process for facilitating constitutional amendments between those generational reviews, which, as Professor Grayling notes, clearly needs to meet the Goldilocks test of being neither too hard nor too easy. I think we need to pay careful attention to the design of the process by which legislation is passed ahead of a ratificatory referendum, ensuring that any amendment really was carefully debated in Parliament would be crucial and yet very difficult to achieve. Our recent experience shows that parliamentary passage of key constitutional legislation can either, on the one hand, happen largely without the public noticing, or on the other, generate a lot more heat than light. And I think an example of the former is the Fixed Term Parliaments Act, which was just seen as necessary housekeeping and in fact turned out to have much broader implications than envisaged. An example of the latter processes of dealing with Brexit in Parliament after the referendum, whereby most of the discussion was about the process of how Parliament should deal with Brexit rather than about the actual implications of the vote. This isn't an argument against Jeff's proposed method of constitutional amendment, which is vastly preferable to the current absence of any agreed process, more a warning against too lightly supposing that parliamentary debate will generate the informed public debate that we would all like to see before constitutional amendment takes place. So those are my 5 points. I've raised some questions about the design of the process, how we could avoid that being overly influenced by elites, how to stimulate public interest in authorship of their own rules, how a constituent assembly could actually be secured, the role of political parties in the process, and the mechanism for interim review. And I'm really looking forward to hearing Jeff's thoughts. Thank you.
Well, an extraordinary set of observations from, if I can say, an extraordinary set of people. I will answer the contributors, the commentators, in order. And I just wanted to begin by saying that having spent a lot of time looking at bills and legislative debates in the last couple of years, I repeatedly came across interventions by Joanna that really strengthened the quality of parliamentary debate and respect for human rights within the chamber, and which were very instructive for me as a legal advisor to the Constitution Committee. Thank you as a voter in this country for those contributions. I'm also glad that you think there's some affinity between your vision of a constitutional convention in Scotland and what I've said. I looked at the platform for independence, Our Future. I looked at the book that was the independence platform for the referendum in 2014, and I thought there was actually a high degree of consistency in what is said in that platform and what I've said, argued for, in this article. One thing you said about the role of a constituent assembly that really caught my eye, and which is relevant to what Hannah has said, is that you thought, and I believe you said that Professor Rennick's suggestion was that the assembly would be composed of 2/3 members of the public appointed by sortition and 1/3 parties. My recommendation was the inverse, for 2/3 party representation, 1/3 sortition. And this is a flaw, I believe, Hannah believes, with the proposal. I want to explain why I came up with that proposal. The thought is that my fear is that if the parties elected on a proportional representation basis would only have 1/3 of the seats, it would mean a very small and diminished presence in the chamber. It would be difficult to account for the plurality of the political parties across the UK or in any national context. And that would mean that the influence the parties have in the process would be weakened, and that would threaten the political buy-in that I think we all agree is very important. But this is something that would need to be discussed at length, I think. I would accept that I've read the politics wrong. I certainly think that people like Hannah and Joanna should be trusted on political possibilities, not to mention Carwyn Jones. But that's the idea driving that view, and I still persist in the view that the parties should play that role for that reason. And let's not forget, factionalism is an issue, but parties have representative legitimacy. They stand for something. Citizens know that they stand for something. They have a sense of what they're asking for when they vote for these people. Remember, under my suggestion, party membership would not be nominated by parties, but it would be elected by the people. Parties would put forward candidates under a closed list system, but people could vote for their representative in the Constituent Assembly. And I think it's quite a realistic possibility. It would be my case that the party I vote for at election time would not be the same as the party I vote for as a nominee to the Constituent Assembly. You had mentioned Joanna, that these ideas could be good for Scotland, but you agree with the criticisms in the first session that it would not be good for the UK. And this, I think, relates as well to what Carwyn Jones had been saying. Clearly a supporter of a written constitution, clearly interested in removing some anachronisms from the UK constitution, such as parliamentary sovereignty, perhaps giving firmer entrenchment to the Sewell Convention, and perhaps even removing the phrase, will not normally legislate in matters of devolved competence. But what we cannot do, you argue, is treat the UK as an indivisible whole. Now, it's not my aim to treat the UK as an indivisible whole. It is to recognize its pluralities in this process. But to give each subcommunity of the UK a veto in the process, in other words, and in particular, to give each of the devolved legislatures a veto in the process, that part, I think, could be difficult for two reasons. First of all, we would be giving a right to the devolved legislatures that I don't think should be extended to the Westminster legislature. If you give that right to the Westminster legislature, all of the reforms that I think you think are important, and we agree are important, wouldn't happen because of precisely the winner-takes-all character of the Westminster Parliament, whose dominance is protected by the principle of parliamentary sovereignty. There's also a question of fairness, of whether even nations as important as the three devolved nations should be able to block constitutional reform elsewhere in the country. This is a very difficult question. We can either try not to address this question and say, let's continue to muddle through as we have. In my view, that continues to give Westminster the dominance it now has. It continues to have the influence that English voters can dominate the system. Now, every time the exercise of codifying constitutions in diverse and especially in multinational polities has taken place, the subnational polities have been given constitutionally secure constitutional arrangements. I would find it very hard to imagine the exercise that I've set out taking place in which things like the nationhood of the three nations isn't in some way recognized through recognizing their institutions, like the permanence clauses have done in the Wales Act and the Scotland Act. And more generally, that the arrangements, the jurisdictional arrangements, which are now weak, that are not protected constitutionally, it is difficult to see those arrangements not coming out protected in the way that is advocated. In other words, that the Sewell Convention is removed and that a constitutional distribution of powers that cannot be changed unilaterally is put in its place. So I respect the idea that it would be wrong for English voters to determine the constitutional future of Wales, Northern Ireland, and Scotland. But I believe that this is what is happening now. And this kind of process could start a constitutional reform exercise where we can provide a relatively equal voice weighted for national differences in a discussion that I think is likely to produce a different outcome. Whether it would lead to the incredible degree of division, whether it would lead to the breakdown of the Belfast Agreement in Northern Ireland, is a question that I find deeply troubling. If it is the case that it would necessarily lead to peace arrangements in Northern Ireland imploding, then I think the argument would not run through for the whole of the United Kingdom. There would have to be some version of Northern Ireland exceptionalism. That's constitution making in a very, very hard case of it. I think that the consociational arrangements would have to persist. My hope is that the reality of the implosion of the peace process in Northern Ireland is so evident to the parties, which are 2/3 of the Assembly, let's not forget, that they wouldn't dare destroy that process. And my hope, furthermore, is that a group of persons chosen by sortition that have moderated discussions would come to see the arguments for national unity, for national difference, for what they are and respect that they need to be respected in constitutional arrangements, just as they are in the many federal countries around the world. On a more basic political level, I would say if I were, and I recognize why the nationalists would not have such an interest in this arrangement. This, I think, to encourage some participation, it's always up to the nationalists to accept their vote and not return any delegates to the convention. But I think that an astute politician that would set this process in motion could make some overtures to try to make this process more attractive even for nationalist politicians. For instance, suggesting that their party would not back any weakening of the current arrangements and would advocate a strengthening of the role of the national institute, the subnational or Scottish, Welsh, and Northern Irish institutions, including, if I were in that position, by talking about confirming a right to hold an independence referendum for Scotland. Yes, I realize that's not so likely, but that, Hannah, these are terrific, you call them practical questions of design and process. They're deeply principled as well. One of the points you made was that you find it hard to see how how any politician in a Westminster party would accept to create a constituent assembly in which they are not playing this role. But as Joanna Cherry has just mentioned, this is the position of the SNP at the moment. So it's not impossible where that kind of constitutional thinking could take place. It's not impossible as well, we might see, if the Labour Party will realize that it is out of power so much, that it is disadvantaged by the system so much, that something has got to change, and this is one way that it could change. Again, may look somewhat naive, but I think there is some value to it. And of course, these issues are being forced to the fore in the Labour Party right now. How can we interest people in the process? From what basis are we beginning the process? These are two separate questions. I think that you require political leadership to say that things in this country are problematic from a constitutional perspective, and we don't need to have the Guardian readers following the events constantly. What we need is to create a process outside of Parliament, and let's see what it produces. If you do see polling, including the polling that Alan Rennick has been doing recently, there's a significant amount of interest in protecting rights and some interest on constitutional questions, at least enough to say let's set a process in motion. The way I think that it would have to start is with a referendum saying, do you want a written constitution and should it be written outside of Parliament? Once the answer is given yes, then you have the legal, I would say, duty of the government of the day to put into motion that process. What do you have in the background? I do think you need to start with the status quo, and I think you inevitably start with a constitutional status quo, and you look at a set of proposals that identify how it could be fixed. I think that it wouldn't be led by experts, but it would be led by the Secretariat in the stuffiest of civil service traditions, which I think tends to work, at least what I've seen in Parliament as well, the House of Commons Library, Lord's Library, briefings, the clerks of the committees, the culture in the committees suggests that this kind of process could be done in a reasonably nonpartisan type of way. I don't think that the status quo will determine the outcome in the sense of blocking all opportunities for changes. I think it would be foolish to rip it up, as Nick was suggesting I was saying, which I don't say, because there are many legitimate expectations about things functioning in a certain way as a result of that status quo. But neither would I be adverse to radical change. But I think the British public and politicians and members of this assembly would probably be adverse to really radical change. Is a parliamentary run process worse than nothing? I'm minded to say yes, because I think the government of the day will pack it with things that will serve it and then make it entrenched and say, well, this is what you'd want it. So no, I think I would fight that at all costs. I think piecemeal parliamentary reform is responsible, but what I'm talking about would end up a written constitution where entrenchment comes up as an option. I would be fearful of that. So I wouldn't support a comprehensive parliamentary-led reform. And lastly, and again, you fear that parties would dominate the chamber, and that I'm perhaps overestimating the extent to which parties exhibit real subtle political insight. Again, I'm tempted to just go along with what you say, but I also feel, and I have nowhere near the experience you do, but watching debates in the Constitution Committee, that parties will probably have a sense of which members they have that really understand deeply the constitutional challenges of parliamentary government in a modern democracy, and would end up putting those forward under a closed list proportional representation system to come into the chamber. But I could certainly vary the formula if that's considered to be wrong. On the more specific questions that you raised, I think I might come back to these if they come up in discussion about consulting Parliament and original legislative authority, because I want to make sure people have a chance to ask questions. Thank you again for these brilliant contributions and for your time in drafting them.
Great, thanks very much, Jeff. Okay, so now we're going to turn open to questions from the floor. If people just want to indicate, yes, I see Ewan at the back there. Hopefully the microphone will work for you this time, Ewan.
Thank you very much, Kate. I've got a question for Carwyn and Joanna and a question for Jeff. Carwyn mentioned McCormick and Lord Advocate, and I wonder what both Joanna and Carwyn think of the argument from people like T.B. Smith 70 years ago that we already have a written constitution in the United Kingdom. The legal argument that the Treaty of Union forms part of our written constitution, a partial written constitution. But more broadly, what is the effect of that constitution on the way that we conceive of ourselves as a nation, which is a running theme through both of these discussions? Does it reserve powers to the territorial regions of the United Kingdom that should not be discussed in a constituent assembly, that should be part of this constitution, behind the constitution, as Stefan Thiel put it? So I wonder what they think about that. And quickly, Jeff, I'm interested in what you've said about the devolved regions in this session in light of what you said in the previous session. And principally, you've characterised that problem as both a problem of veto, whether we can grant a veto to devolved regions, but also a technical problem of how we arrange the relationship between Westminster and the devolved regions. And I'm not sure that's the problem. I think the problem is that a durable majority of people in Scotland, a slight minority of people in Northern Ireland, and as Carwyn said, about 30% of people in Wales think we don't just need one written constitution, but at least two. That is the principal constitutional issue for people in those regions, regardless of where they stand on it. And any discussion of a written constitution that does not include that issue would be a chimera for those people. On the other hand, the central state thinks that can't be on the agenda at all. How can this sort of constituent assembly foster the sort of pluralism that you think is a political precondition for a written constitution if those people in those regions can't have that issue on the agenda? And how can you get that through the central state if you think it should be on the agenda?
Thanks very much, Ewan. I thought we'll take another 2 or 3 questions and then deal with them. Yes, Nick down here. Thanks, Greg, here at the front.
Well, thank you very much. It's just a footnote to Ewan's question and a comment on Carwyn's presentation, which I agreed with almost entirely. The bit I disagreed with, though, was I would question if parliamentary sovereignty is indeed still a feature of the United Kingdom Constitution, and those who know me will be rolling their eyes. So I think it's been a fiction for the last 30 years. And if there ever is an act of the United Kingdom Parliament to abolish the Welsh Parliament, call me in, because I could give you probably 3 good, strong arguments that at least be worth having a crack at in the Supreme Court to argue that the United Kingdom Parliament doesn't possess that power.
Okay, any other questions here? And just a reminder to those of you who are online, we will pick up your questions if you put them into the Q&A. Yes, at the top.
Hi. Jeff, you mentioned that if there would have to be a referendum for a written constitution, but my concern is how do you, like, if the voters aren't actually educated as to what they're voting on, because we saw that a little bit with Brexit, and, you know, for me it jumped to mind, like, maybe you test people, but then it's sort of a bit reminiscent of Jim Crow literacy tests. So it's just, how do you, is it really democratic if people don't really know what they're voting on and don't fully understand? And is there really a way to, like, combat that? Because you can't exactly prevent people from voting just because you don't think they're ready. So just, yeah, what do you think of that? Thank you.
Great, thanks very much. So, Jeff, I'm going to hand it over to you to answer, then we'll give members of the panel, and then we'll have one more round.
Thank you. So, Ewan, you'd said that the problem is not, as I put it, that, you know, managing the technical problem of how we arrange the inclusion of voices from the devolved nations, or even of overcoming, dealing with the legitimacy question of whether vetoes should exist. You think that the problem is deeper, that there are two, the desire is for two separate constitutions. I think by that you're saying that the independence movements in each of these areas are aspirations for a wholly different kind of constitutionality. In my view, as long as independence hasn't been chosen, that is a reality we need to deal with. But there is a desire as well to preserve the union at the present point in time. That should not be ignored for lots of reasons, chief among them because that is still the majority of the position of the electors that are there. Preserving the union not only in the sense that a central government for the United Kingdom might be something that these voters would want to keep in existence, and to endow with powers in the name of those nations to carry out foreign affairs. But also because by adopting this process, they can further secure their own position, their own jurisdictions in these arrangements, namely the powers that are given, the devolved powers. And I'd actually, in coming today, I'd thought quite a bit of how you could address the problem of the flux of devolution, how the things are changing and under the model that I have. And I have things to say about that. Essentially, I think that you would have a system where further powers could be devolved with mutual consent from the devolved assemblies in the Westminster Parliament without taking it back to the people. But generally speaking, I think that you're not muting the aspirations for independent statehood by engaging in this process. If anything, the likely outcome is that you will give recognition, just as in the Scotland Act 2016, there was recognition of the nationalist sentiment by saying that the Scottish Parliament is permanent and that the Sewell Convention should be recognized legislatively. I'm not saying that those desires have been satisfied, but I think that we can provide a more satisfactory answer through this process than the current one, which gives Westminster overwhelming power. Nick, I think that your dismissal of the doctrine of parliamentary sovereignty may be a bit premature. It is a very real fact that the government thinks it can do what it wants in Parliament, and it also, by getting a majority in Parliament, and it will dispense with principles like the rule of law, it will enact retroactive legislation, it will disable the application of the Human Rights Act to certain forms of legislation. These things can and do happen. And although the Supreme Court huffs and puffs from time to time in certain decisions, the day-to-day reality is that what happens in Parliament is going to be followed in the overwhelming majority of cases. The question about a referendum, you know, it is a challenging question, but for the same reason, literacy tests should not have been used in the Deep South. We shouldn't be asking whether or not this is a kind of question that people are grown up enough to answer. The way it works in reality is that many voters, most voters, will take the cue from the political parties that they've been affiliated with. They will listen to what their party has to say about it, and those that want to explore the question in more depth will look into it and make up their own minds. If we think that we can go to the electorate for a lot of big questions like how to run the economy and so on, then I think we should also think that we can ask them whether this type of process, whether a written constitution, which is right in front of them, and they can pore over clause by clause, I think that it would be fine to give that question to. I don't see them as different in terms of the technical expertise required. Thank you.
Pardon me, Ewan, could I ask you to repeat the first part of your question to me in Carwyn, because I'm afraid I missed the first part of it, for which I apologise.
So, Joanna, the question's about whether we already have a written constitution in the form of at least the fundamentally entrenched provisions of the Treaty of Union. So what do you think of that legal argument?
Yeah.
But more broadly, what does that mean for the way we conceive of ourselves as a nation, a question that we looked at in the first session, and does it reserve certain things from this process of constituent assemblies that shouldn't be able to be discussed in a UK context?
Yeah, well, I mean, obviously, I'm very interested in the argument that the Treaty of Union, aspects of it at least, should have a character of a higher law or a sort of constituting law of the United Kingdom. And those issues have never been properly or fully explored in the Supreme Court. They've actually been raised in quite an interesting case in Scotland recently, where a member of the public crowdfunded to try and get an answer to the question of whether or not the Scottish Parliament can hold an independence referendum without the permission of the UK Parliament. But the respondents were both the British and the Scottish Government, although albeit the Scottish Government were, it was the Lord Advocate who appeared, but he's making arguments on behalf, it was still a he then, now it's my good friend Dorothy Bain, but making arguments on behalf of the Scottish Government. And very much the argument was that the argument that it was premature until you actually had a bill to look at to see whether the bill was within the four walls of the 1998 Act sort of triumphed. So the matter wasn't looked at properly, but counsel for the petitioner was Aidan O'Neill, and he explored these arguments in his opinion. His opinion's been published online. But I got the impression that the Scottish court wasn't really terribly interested in those arguments, which I found quite frustrating. And I have to say that the decision of the Supreme Court a couple of weeks ago in the case striking down certain aspects of the bills of the Scottish Parliament to incorporate the United Nations Convention on the Rights of the Child, and I think it's a European Local Government Charter. Whereas one might think that the outcome of those cases is probably correct on one construction of the Scotland Act. I think the Supreme Court went a bit further than needed to do, and I know a lot of people, including my friend Aileen McCarg, hold that view. And I think it doesn't augur well for any of those sort of arguments. If we still had Lord Hope in the Supreme Court, I think arguments about a sort of a fundamental constitution of the United Kingdom, the death of parliamentary sovereignty, would probably be would fall on more sympathetic ears than the current Supreme Court. And much as I'm a Scot Nat, I'm a big fan of the UK Supreme Court, not just because I once won a big case there, but also because I think they look at things very thoroughly, and I really like their approach. But I do think in relation to Scottish cases, they've not shown any huge appetite to engage in that argument. And if you look at the way they dealt with Sewell and Miller 1, very dismissive of any kind of idea that Sewell had any sort of really meaningful status. And as I say, I think the decision in the UN case, the bill about the UN rights of the child, is a real setback for those of us who would have liked to see a more expansive approach to constitutionalism. And I'm afraid on this occasion I don't agree with Nick that parliamentary sovereignty isn't still a feature of the UK constitution. I really believe it's a very strong feature of the UK constitution. Certainly the party of government's never done banging on about it at Westminster. And I'd love to hear Nick's the arguments that the UK Parliament couldn't abolish the Scottish Parliament, because I think it's pretty clear from some of the dicta in that recent UK Supreme Court that it could abolish the Scottish Parliament. There's not terribly much we could do about it. And obviously we have, someone mentioned the case of McCormick against the Lord Advocate, 1950s case, where there's some arbiter dicta about the sovereignty of the people being the constitutional position in Scotland. How far that really takes us in reality, I fear sometimes not particularly far. But of course, these arguments may yet be revisited in the Supreme Court. The makeup of the Supreme Court changes from time to time, and it would be really interesting to see them litigated at some point in the future. Finally, I'm really sorry I missed your name, but I thought your question was a really good question, because I think you're right. A lot of people are going to be like, a referendum on the Constitution, what does that matter to me when I'm trying to manage without my uplift in universal credit and that sort of thing? But I think, as I understand it, what happened in Ireland with their citizens' assemblies on really big issues like abortion and equal marriage is that there was considerable buy-in from the public, because these things were televised, and there was quite a lot of public buy-in and discussion. Now, I suppose, speaking from my own perspective, the very fundamental issue of whether one should have the right to equal marriage is perhaps more engaging than a written constitution. Ditto, as a woman, the abortion rights are perhaps more engaging than the issue of a written constitution. So I think it's a very valid question. How would you get enough people properly engaged and interested to vote in the referendum to give it the sort of legitimacy you would want? Because if you had a very low turnout, it would sort of make the thing all a little bit of a damp squib. Thank you.
Thanks, Joanna.
Well, thanks everybody for your questions. I think the first question you asked was, does the UK have in effect a written constitution now? I'd argue that it doesn't, because people talk about the Act of Union in 1707. In reality, we know it was a treaty between two sovereign states where they became one sovereign state. It wasn't really designed to set up a new constitution. It was silent on a lot of issues. I think the issue in McCormick and Lord Advocate was over whether Queen Elizabeth should be the first or the second in Scotland. And because the treaty was silent on that point, it was left to the royal prerogative, which is a fantastic way of sidestepping the whole issue. But of course, as Joanna said, there is overturn in that case that suggests that if the UK Parliament decided to interfere with a treaty provision, such as the position of the Church of Scotland, or if it tried to abolish the Scottish legal system, then the suggestion is that the courts would say, hang on a second, you can't do that, therefore there are limits to UK parliamentary sovereignty. Dicey, of course, took the opposite view. Dicey took the view that the UK Parliament could abolish the position of the Church of Scotland, or could abolish the Scottish legal system. Tough luck, but that was in line with somebody who was, well, he did oppose extending the franchise to women as well, and he opposed Home Rule for Ireland, but nevertheless his word is law when it comes to parliamentary sovereignty, apparently. So I don't think there is a written constitution. I think in some ways Wales and Scotland have got that. The Welsh constitution is based on four Westminster Acts of Parliament, 1998, 2006, 2014, 2017, different Wales Acts that set up the what is now the Welsh Parliament, the separate existence of the executive in the form of the Welsh government, and powers, how they're distributed, and what tax varying powers and so on that the Welsh government and Welsh Parliament have. So in that case, there is a kind of written constitution there, but I don't think we can go as far as to say that the UK has one. Nick, I wish you were right, and I wish it was correct that parliamentary sovereignty has somehow disappeared. I don't think it has. I think that the Supreme Court's come close to it, and there have been some comments about, well, what if the UK government, what if the UK Parliament decided to abolish the court system? Does that mean that they should be allowed to do it? Now, it's in extremis, of course, that kind of example, but the suggestion is, well, no, the Supreme Court would stop that from happening. Whether they do the same, if there was a sudden rush of blood to the head in Westminster to abolish the Scottish Welsh Parliaments, we'll have to wait and see. And I suppose the example would be Sewell. Sewell is mentioned in statute for Scotland and Wales. The Supreme Court said Sewell isn't justiciable. The only way you can really say that is if you accept that if you make it justiciable, you limit UK parliamentary sovereignty. Therefore, if you don't want to do that, you can't make it justiciable. That's the only way I can get into my head the idea why they decided that civil wasn't justiciable in the first place. But there is nothing to stop the Supreme Court deciding tomorrow that from now on they're going to limit parliamentary sovereignty or not recognise it at all. You know, that's the chaos that exists at the heart of what passes for the UK's constitution at the moment. And then the UK Parliament will say, well, we're not going to accept that. We're going to pass an act of Parliament telling you, the courts, what you can and can't do. And the Supreme Court will say, we don't recognise that act of Parliament, actually, because we think that this goes against common law. And there it goes, round and round in a circle, which is, of course, an argument for written constitution, Jeff, as we know. Third question, then, is people's understanding of the question, a really important question. Wales has had 12 referendums in the past 60 years. 6 of them have been on Sunday drinking. Last one was in 1996. One time all the pubs were shut in Wales. The clubs could open. They could open and hotels could open for serving guests, as it were. And in 1996, the last county in Wales went wet, as it's called, so it allowed its pubs to open on Sunday. We had 3 referendums on devolution. 2 on Europe and the ATV referendum back in 2010. The most difficult one of all was the 2011 referendum, because at the heart of the 2011 referendum was asking people in Wales to vote for primary lawmaking powers, the ability to pass acts of Parliament. But those powers were contained in the 2006 Government of Wales Act, Schedule 5 therein, and they had to be brought into force via a referendum. The Electoral Commission said the referendum question has to be a question based on that particular part of the Act. It was 2 paragraphs long, and it made reference to the schedule in the Act, basically saying to people, do you believe that this schedule of this Act should be brought into force, without explaining what it meant? Now, that was a real problem for us. We boiled it down in the end to one sentence. Do you believe that all the laws that only affect Wales should be made in Wales? 2 to 1, yes. Because that was an easy question. But you're quite right to say a referendum, the validity of a referendum is affected if people don't understand the question. People understood what leaving the EU meant, roughly. They thought, they didn't understand the mechanics of it, but they had a fair idea of what it meant. You know, they understood the question, even though, you know, all manner of things then happened as a result of that. But if people don't understand the question, they will then start listening to people who are trying to distort the meaning of the question, and that's why it's so important for something. If you talk, Joanna's right, if you talk about a written constitution, it's such an obscure issue for most people. They won't know what you're talking about. There's a massive exercise in informing people of what they're being asked to decide, and that actually is by far the biggest difficulty. If you can get that right, then you can have a proper debate and you can win a referendum. But it is really hard. In 2011, we really had to work hard to come up with a strapline that explained what was, you know, 2 paragraphs of legislative drafting.
Thanks, Carwyn. Hannah.
We don't actually be getting the questions with me, but I'd like to hear the next case for the death of parliamentary sovereignty.
Okay, we give Nick a microphone to tell us about parliamentary sovereignty and why it is dead.
That's it.
Okay, so first off, try reading chapters, I think it's 4 and 5 of my new book, which explain definitively why parliamentary sovereignty. The very, very brief answer. When people talk about parliamentary sovereignty, it's very important to know what parliamentary sovereignty is. And I think you're right, it goes back to Dicey. And if you look at Dicey, what Dicey said was everything that Parliament enacts as statute is law. Everything the Queen in Parliament enacts as statute is law. And that meant that every time the Queen signs the royal assent and the thing falls off her blotter, hits the corgi, that's valid law, full stop. Yeah. That I think was a rule of the United Kingdom Constitution right up until the Factortame case in the early 1990s. And in that case, the House of Lords said, no, it is not necessarily the case that everything the Queen in Parliament acts as statute is law, because this particular piece of legislation that conflicts with the European Union Act, European Communities Act, is not going to be applied in this case. So they decided not to apply a statute in the case before them. So much more to be said about it, but that's my argument, that parliamentary sovereignty died in 1990 because the extreme version that Dicey gave us went. And since 1990, you see the creation of constitutional statutes, you see the emergence of constitutional principles, and it's a new approach to the way in which the courts respond to statutes. Now, if there was a rush of blood to the head and Boris Johnson tried to abolish the Welsh Parliament, and goodness knows there are plenty of rushes of blood to Boris's head from time to time, there are a number of arguments you could use. It does depend on the courts being willing to run with them. Yeah? You could argue that the definition of Parliament had been redefined in the Wales Act. You could argue that the Welsh statutes were constitutional statutes and ranked above the repealing statute. You could run an argument based on constitutional principle that this was disenfranchising the people of Wales. And all three of those, I think, are arguments that the Supreme Court could, if it wished, take on and adopt and use to stop the Welsh Parliament being removed. But I absolutely concede Joanna Cherry's point that in Miller they didn't cover themselves in glory in the way they dealt with the Sewell Convention, which I think is justiciable, just not enforceable. They could have pronounced on its applicability even if they didn't hold it as a constraint on what Parliament can do. You did ask me, Kate, and it could have gone on for a good half hour or an hour.
Thanks, Nick. I do feel a rabbit hole might open up here if we're not careful. Are there any other comments or questions from the floor, and anything online, Gayatri? Do you want to just put it in fairness to the people online?
So the attendee asked for the referendum on the potential constitutions. Would there be conditions put on the turnout or the result? A constitution which only has the support of 52% of the electorate seems like it would struggle to succeed or unite the people.
So a sub-minimum, in other words, of people who had to vote. Jeff, you might like to respond to that. I'll just see if there's anybody else. Yes, thanks. Go ahead.
I'll just start by saying that I'm not British, so this is my perspective as an outsider. But it seems to me that UK constitutional politics is heavily relies, and also the political behavior of British agents from all nations heavily relies on trust and confidence that everyone else is going to behave reasonably. And it seems to me that part of why this happens is because the lines are blurred. And therefore, because the Constitution is not written, it seems to me that when I'm thinking from a behavioral perspective, that there is some sort of conscious self-restraint that is coming exactly from this. I mean, I don't know exactly what the lines are, therefore I'm going to moderate myself because I also expect other people to act reasonably. And this for me is a good, as an outsider, it seems to me that this is why the system functions in such a reasonable way, and there is moderate agreement. So my question is, if we kind of adopt written constitutions in which I don't need to be so self-restrained and consciously about that, would you think that relationship between powers would be more adversarial? Like it would be less moderate in a sense, and this would be bad even for British politics overall.
Thank you.
Oh, I'm sorry, can I just add a second point? That is, it was mentioned ratification of constitutional referenda by all the states, the 4 states. And I just want to know, coming from, I don't know, a literature that discusses why electoral college, for instance, is undemocratic in the US. Why adopting a ratification not per person, per capita, but per nation would be more democratic for a new constitution?
Thank you. Any other questions from the floor? Yes, at the back. Yes.
So, this is Nick responding to Nick. My understanding of the constitutional statutes doctrine as laid out in Thoburn is that it would only protect a statute from implied repeal, not explicit repeal. So you could argue that in front of the Supreme Court, but surely it wouldn't protect the Wales Act from the government explicitly coming after it. So, I just wanted to note that.
Thank you. Right. Hannah, you want to say something? Yeah. Yes, please. Go ahead.
I just wanted to respond to your question. I think you're totally right. The historian Peter Hennessy describes it as the good chaps theory of government, that everyone will just be a good chap, which is wrong on many levels. But I think that you're right, that it's, it might seem desirable to have a system in which, it's less adversarial and that people act within boundaries because they want everyone else to act within boundaries, and they might not be sure where the boundary is, and therefore they act in a more moderate way. If that's how people act. I think at the moment we're more in a situation. I had a former senior civil servant said to me the other day, it used to be that ministers would come and say, this is what I want to achieve within the rules, how can I go about achieving this? But now ministers come and they say, where does it say that I can't do this? And actually, if that's the situation you get into, then actually it's almost, the current government might not think it wants a written constitution, but it's almost pushing us towards a more written constitution, because actually, if it's constantly going to be at the boundaries of what can be done, then people are going to want to know where those boundaries are. So.
Okay, great. Well, I won't be too long here. Thank you. Just to address the questions that were posed. The one that was posed online, are there any limits to the referendum? So, the two classic limits that are envisaged are turnout requirements and vote threshold requirements. I wouldn't recommend either. The Constitution Committee also, which has a report on referendums in the United Kingdom, which I'd recommend to anyone who's interested in this subject. They also talk about constitutional referendums, written constitutions on the list. They have many negative things to say about referendums, but they recognize the case that if you're going to have them, constitutional matters would be important. They say thresholds on either of those levels are not a suitable thing because they can have a conservative impact. They can be counter-majoritarian in their effect. And I tend to go along with that conclusion, but it does present a very real political question, which is the damp squib problem that Joanna Cherry had identified. What if the Constituent Assembly takes 2 years to draft a magnificent constitution, and then it's supported by very few voters in the outcome? I think there is no way around this issue other than to engage in a public education exercise and get the message across that this is really important politically. Okay, this will in some ways redefine the way politics works in the country. If that message, if there's no take-up of that message, well, it's a failure of politics in general. And I think whatever the outcome of the referendum exercise, you need to go with it. And if it's no, we don't want it, then I think you probably default to the Constitution that we now have, which would be a shame. Would codifying eliminate customs of self-restraint? I think there's a follow-up piece by Peter Hennessy, Good Chaps No More, ? I think. Right, I think the view that self-restraint is the sort of leitmotif is really losing its force. That was one of the reasons why the Miller-Cherry case was considered to have been, by many observers, absolutely what the Supreme Court did, which was to take a massive legal step forward, and what they recognized was justiciable before the court, rightly, I think. But it was viewed as the court saying the government is pushing things so far, stretching conventions and all of those understandings about what was permissible, the duration of prorogation, that we would push back. But that's just one isolated example. There are many instances. The Internal Market Bill last year, the way that the Northern Ireland Protocol was handled. Again, when you start fiddling about with legislation, the taking of delegated powers in extreme forms, the parliamentary scrutiny of delegated legislation generally. The view is, I think, the right view is that these norms of self-restraint don't really apply so much anymore to legitimate the current system. So I should finish very briefly by saying that the most difficult challenge, I find it interesting that all of the commentators today recognized the possibility, and I think even ultimately the desirability of having a written constitution, few were convinced about the method that I proposed for doing it. But if we were to adopt a written constitution for the UK, for any of the other reasons that we've been discussing, if we think the status quo is somehow defective, then it's incumbent on us to come up with a procedure in which these questions can be addressed in an egalitarian fashion in this large multinational community that we are in. And I think that giving weight to the view, putting the issue high up on the agenda where it needs to be addressed, by giving each individual a strong presence in the chamber, as strong as one can have in an electoral democracy, giving additional representation not just to the home nations, and possibly England is a question we haven't even discussed, but not just to the home nations, but also to the multiplicity of other groups that need to have their voices heard in this exercise, is a challenge. But I don't think that the current constitutional arrangements respect the equal dignity of all of those groups any better than what is put on the table here, so long as the UK will persist as one polity in which all of these nations form part of the community. I think this is one of the better ways to go about respecting those claims to equal treatment. So I will stop there, and thank you very much, and thank you to my commentators for their brilliant criticisms and contributions. Thank you.
Well, it just falls to me to thank all our panelists. Thank you very much, Anthony and Chris, who's had to leave us, and Carwyn and Joanna and Hannah, and of course, particularly Jeff, for a really thought-provoking afternoon. I mean, I think I'm left with the sense that there's almost a paradox here, that the strongest reason probably for the UK Constitution, which is that it is made up of 4 constituent parts in which clarity is really required particularly strongly, arguably makes it the most difficult in ways to find a way to do it in which all those 4 constituent parts will feel an even strength. And for those arguments that I think that Chris and Joanna and Carwyn have put, I think we're very grateful. So for those of you who are here, please join us outside for a glass of wine, and to thank all of those of you who have joined us online, and hope that we will see you here in Oxford at some stage in the near future. Thanks very much, everyone. Just one last thanks, both to Stefan Thal, who couldn't be here today, but who was signally involved in setting this all up and did a great job. Thanks, Stefan. I know you're still watching. And also to our great technical team, Greg and Gayatri, who kept us on track. Thanks, everyone.